citizen's right to film government officials and the discharge of their duties as in a public space is basic, vital, and well-established liberty, safeguarded by the First Amendment.
Their conversations were being taken down on video and put out on a YouTube channel. Your Honor, this is entirely unlawful.
I have no idea whether or not your client committed disorderly conduct under the statute. I cannot dismiss it. The state's attorney has a right to charge whatever the state's attorney wants to charge.
Hey, what's up guys? Long Island Audit here. Back again with another video. This Zoom hearing for my motion to dismiss was sent to me anonymously, and I thought it was very important I share it with all of you. You will see how absurd the state's attorney's argument was, and honestly, I can't understand how the judge denied my motion. But as we all know, my disorderly conduct charge has since been dismissed. We the people won. Stay tuned to the channel for updates on the incoming federal lawsuit. Without further ado, let's get into it.
Okay, so I have had an opportunity to read both of the motion to dismiss that was presented to me on behalf of Sean Paul Reyes, on behalf of his attorney, Mr. Jinks. And I also have had an opportunity to review the response that was submitted by the state's attorney, Ms. Dunbar. I asked Mr. Reyes' attorney if he wanted an opportunity to file a written reply to the response that was given by the state's attorney. He has declined to do so. He has notified me that he is ready to proceed for hearing today on the motion to dismiss. So I will go ahead and proceed. In counsel, you can go ahead and use the podium. Okay, go ahead, Mr. Jinks, and you may proceed.
So on the date in question, my client, Mr. Reyes, entered the Berlin City Hall building. He's an independent journalist who travels around the country promoting government transparency with public officials. On that date, he entered the Berlin City Hall, and on the front of the building there's a sign, "No cameras or recording devices without prior approval," per statute 720 ILCS 5, Article 14. Now after he entered the building, he entered a public area. He never went anywhere that was off limits to the public. He was in public areas at all times. And he also has a First Amendment right to film. There's a fundamental right. This is well-established law. And when he did have individuals who were village administrators, one being the complaining witness, approach him and ask him to stop recording. He declined, but while the complaining witness directed him, saying he can't record, and as an example, referred to the sign posted out the front door. However, that sign, per that statute, was found unconstitutional in Illinois back in 2014, which is the eavesdropping statute, which had to do with surreptitious recordings.
What case found that unconstitutional? Do you have a
I may not. I can supplement that.
Okay, go ahead.
So that statute was found unconstitutional for the eavesdropping statute. Even as such, that eavesdropping statute, which he was not charged with, he was initially arrested for it after he left the building, but he was never charged for that statute due to its unconstitutionality. And he was later charged with the disorderly conduct, which we're here for today. There's nothing that they alleged that, besides his filming, was found to cause the ultimate arrest. For the disorderly conduct, it has to be an unreasonable action that causes the alarm. Most importantly, being the unreasonable. So, and being a constitutional fundamental right, that can't be deemed unreasonable. Nothing of his actions besides the filming itself and them asking him to stop and declining is what caused the complaining witness to say that she was alarmed. No other actions, no yelling, no screaming, it was very polite. It's not alleged that he was angry that caused the charge of reporting crime. And again, the complaining witness is a village administrator, so he's obviously a public official. And the cases I cited, ACLU versus Alvarez, 7th Circuit case from 2012, affirmed a First Circuit case, Flick v. Kunin, 655 Federal 3rd 78. The Alvarez case from the 7th Circuit affirmed the position taken in the Flick case, where Boston police officers were being filmed by a citizen, the same way this was. And that First Circuit held that a citizen's right to film government officials and the discharge of their duties in a public space is basic, vital, and well-established liberty, safeguarded by the First Amendment. It's not disputed that the complaining witness in this case is a public official, that she's a village administrator of Berlin. It's not alleged that Mr. Reyes entered anywhere that wasn't public. He was in the public hallway of the town hall. It's obviously a public place. And he was filming a public administrator in the action of her duty. There's an Illinois case where of disorderly conduct and people be Cody. There must be some relationship between the accused conduct and public order, or between the conduct of others not to be harmed or molested. And sorry, 1 second. And the defendant, pretty much the case law as it stands has to do with the unreasonableness of the actions. The culpability revolves around not only the type of conduct, but is dependent around the entirety and surrounding circumstances. And People v. Bergeson, 255 Illinois Appellate Court 3rd 601, a 1991 case. The defendant in that case was charged with disorderly conduct. This is not page 401. Motion.
I do see it.
The defendant in that case was charged with disorderly conduct. He was in a common area of his apartment complex, and they accused him of peeping in a window of a woman undressing in her apartment. They charged him with disorderly conduct. However, the court said that his conduct was not unreasonable because he was in a public place, somewhere he was permitted to be, and that he didn't do anything wrong being in the public place, simply viewing something from that public place. Even though the woman wasn't dressing in her apartment, he had a right to be there, so it can't be deemed unreasonable. Even though it was alleged that he was staring in a window, the burden is on her to close her window. In public, Judge, there's no expectation of privacy. This is well-established law. It's the same doctrine that the police use it for plain view searches against the warrant exception, one of the warrant exceptions. If something's in plain view where they're permitted to be legally out in public, they can get around the warrant requirement because it is in plain view. This goes to the same thing. If it's in a public place, you can see it, you have the First Amendment right to film it. There's no difference if I can see it with my eyes than filming it with my camera. Being in a public building, filming a public administrator in the action in the act of fulfilling her duties as a public official, he completely has a right to do it. He didn't, he was asked to leave, but however, he does have the First Amendment right. He initially, after he leaves the building, the police approached him, and again, keep referring to the sign, which is already called unconstitutional. They initially arrested him for that, and then I believe that they kind of bumped it down to the disorderly conduct pretty much to protect themselves from a false arrest lawsuit. So I think that, and that's my opinion, that appears to be what they're doing, especially since she is a representative administrator for the city. The eavesdropping statute, which they kept referring to, which was found unconstitutional, And the state, where it keeps referring to in her response, has to do with surreptitious recording. He was open and obvious, his camera was out, they knew he was filming, he wasn't hiding anything. So even if it was still good law, the eavesdropping statute still would not apply. The entirety of the state's response and position had to do with consent. We mentioned in my motion that due to the security cameras being throughout the village hall, she should not be alarmed by someone else filming them without them interfering. The defendant was simply just filming from his camera, and you can't sit there and feign alarm because simply for being filmed when you're being filmed all day by security cameras. The state incorrectly argues that that's a consent issue. My argument was based on the alarm, which is required under the disorderly conduct statute. The state incorrectly argues that that we mentioned the security cameras based on consent, that she's consented to being filmed by security cameras. This isn't a consent issue. When you're in a public place, you don't have to consent to being filmed. There's no expectation of privacy in a public place. So consent isn't even a relevant argument. And that's pretty much the entirety of the state's position, is that they didn't consent to being searched, didn't consent to being filmed, and therefore their First Amendment, Mr. Reyes' First Amendment right is somehow null and void. If that was the case, anytime someone has a protest or someone uses any of their First Amendment rights to videotape, to protest, freedom of speech, and it bothers one individual subjectively, even though that would completely remove any First Amendment right because one person is bothered based on fundamental protected activity. He has a First Amendment right to film. He's in a public place filming a public official. Besides that, there's nothing that the state has argued based on his actions that could even be found in you. Again, if they're going to argue that he needs permission from people from the village to record, then we get into prior restraint arguments for those same constitutional rights. So based on all that, his actions, nothing he can do, nothing he's alleged to have done, based on his First Amendment protected activities in filming the public official, nothing can be deemed unreasonable. And if it's not unreasonable, then the disorderly conduct statute charge makes me. Thank you.
Okay. State, you can go ahead and proceed.
Thank you, Your Honor. First and foremost, Your Honor, I would just like to make very clear there is no allegation in this matter that Mr. Reyes was in any way prevented or told that he could not be present in the public location for City Hall. Now, throughout counsel's argument, he had referenced the administrators who were present. And Your Honor, it's very clear in the police report that the complaining witness in this matter, Alyssa Green, she did sign off on the complaint. She is the city administrator. However, there are multiple additional witnesses who are listed throughout the police report. Upon signing the complaint, upon notifying the police who are located in the same building, Ms. Green did indicate that there were people who had brought Mr. Reyes to her attention, as well as several of the employees working in her stead who felt uncomfortable by his presence and consistent reporting. Your Honor, one of the follow-up arguments that was made by counsel is with regards to filming and effectively saying that the people working at City Hall were feigning alarm when they notified the police that multiple people that were employed by the village of City Hall were made uncomfortable by his actions. Your Honor, the state referenced in our response to counsel's motion that Mr. Reyes was filming these recordings, as counsel indicated, for dissemination based on his status as a journalist. the filming that takes place within City Hall very specifically and very intentionally, based on state requirements, is visual only. It only records what people are doing. There is no audio recording whatsoever. And you're on the video that was taken by Mr. Reyes and eventually disseminated through his YouTube channel was both an audio as well as a visual recording. The state made reference in our response that the state of Illinois is a two-party consent state. Now, if Your Honor chooses to take a position that the secretaries, as well as the administrator who represented them working at City Hall, are fully considered under the public official requirement, that they can be recorded in public, that does not take into any consideration who was continuously mentioned in the state's response of the private citizens. Because it's a public building, there are private citizens located within Berwyn City Hall. There were multiple people that were on the phone with city administrators, and by Mr. Reyes being present in both audio and visually recording these people, he was recording their private conversations that were being had. And Your Honor, the requirement of that is laid out in the state's response that people do have a protected right to not have their phone conversations intercepted by a third party. Not only intercepted, Your Honor, but disseminated through his YouTube channel. And again, with Illinois being a dual-party consent state, there was no indication that people even knew that they were being recorded, let alone that their conversations were being taken down on video and put out on a YouTube channel. Your Honor, this is entirely unlawful. And based on that, he was asked merely to stop recording. He wasn't told that he couldn't file when he went into file. He wasn't told that he couldn't be there. He was merely asked to stop recording, and he refused. Now, Your Honor, in response to Mr. Jenks' statement regarding feigning alarm, feigning alarm by the complaining witness. Your Honor, the state would ask the court to take judicial notice that upon arrest, Mr. Reyes his information was input into the lead system and an arrest card was generated. Your Honor, both the arrest card and a leads showing the defendant's any criminal history that he may or may not have indicates that he is listed as 6 foot 2 inches tall and 270 pounds. Now, Your Honor, counsel is in no position to tell someone what alarm disturbs them or provokes or disturbs their peace, particularly when someone of that stature enters into City Hall, is recording conversations that are not only going on between employees of City Hall, anyone who is working underneath them, anyone fielding phone calls, and any of the private citizens that are present. But he also is not in a position that when they ask him to stop recording, specifically to stop audio recording those conversations between the private citizens, and he refuses, or he is not in a position to decide whether or not that alarms someone when their conversations are being recorded. Now, Your Honor, the case law that was cited by counsel, as I stated in my response, is almost entirely specific to the reporting of police officers, and we would ask that the court give it the appropriate weight based on that. And adopting all the additional argument that is included within my motion, Your Honor, we would ask that you strike down counsel's motion to dismiss, based first and foremost on the fact that he was recording and disseminating private conversations without consent of any of the parties, which the state's position is an initial disturbance of the peace. And finally, upon being asked to stop recording those conversations, refusing to do so, therefore further disturbing the peace before it was, again, disseminated without the consent of any of the parties. And again, an adaptation of all arguments included in my written motion, we would ask that you deny counsel's motion.
Okay, any rebuttal, counsel?
So the state continues to mention private citizens that were being recorded. It's not relevant whether there's private citizens being recorded or not. This is a public space. There is no expectation of privacy in a public space. The complaining witness is not a private citizen. So arguing that a private citizen who's not even a complaining witness is somehow alarmed isn't even relevant in this argument because none of them signed the complaint. They have nothing to do with this. And that the state alleging that some of them made complaints doesn't matter. Even if the alarm by the complaining witness was real, even if she actually was alarmed, it still does not take away the fact that she's a public official in a public place with no expectation of privacy being filmed by Mr. Reyes, which he has a First Amendment right to do. Even if one individual is actually alarmed, Mr. Reyes' conduct was not unreasonable, and that's the standard under disorderly conduct. Were his actions unreasonable, objectively unreasonable, that would cause the alarm and somehow be found guilty under disorderly conduct. Doesn't matter if she was actually alarmed. If that was the standard, it's a slippery slope to remove fundamental right. The First Amendment right would be gone in any protest, any filming of anyone, simply because one subjective person is alarmed. Again, he's not alleged to have yelled. He's not alleged to have approached her in a threatening manner. The only conduct by Mr. Reyes that is alleged to have caused alarm is simply filming and being asked to stop him and saying no. Doesn't matter how big he is. Simply filming does not somehow impose a threat objectively on the complaining witness. The state also mentioned that Illinois is a two-party consent state. Again, she's arguing the unconstitutional law for eavesdropping. Eavesdropping has to be done surreptitiously, not out in the open. It has to do with secretly recording conversations between people.
Hold on for a minute. I'm hearing noise. Go ahead, Counsel.
The eavesdropping in Illinois has to do with surreptitiously recording private conversations. It cannot be assumed to be a private conversation when you're out in public. Being out in public, again, has no expectation of privacy, which anyone out having a conversation, the people next to you can hear it. If it's in public, you can record it. You can see it, you can record it, you can hear it, you can record it. As long as it's not done surreptitiously in a private conversation. So the eavesdropping statute that the state continues to argue is irrelevant as well. This would be the same relative to an attorney having a conversation with a client in public. We know that privilege is that waived, and they can't use that privilege if there's somebody nearby that can hear it because you're not in a private setting. This would go back to the same type of situation where if you're in public, there's no expectation of privacy. That is the biggest, strongest argument in favor of Mr. Reyes. Again, this is well-established law. It is a fundamental right and simply cannot just be taken away. You simply cannot take away someone's First Amendment rights to film simply because one person is alarmed. Even if that alarm is, even though if they're actually alarmed, it still doesn't matter because it has to be done on the objective unreasonableness of the person's action. And a fundamental right cannot in and of itself be deemed unreasonable. Thank you.
Okay, thank you, Counsel. Okay, as I stated before, I did read both of the motion to dismiss and the response in its entirety. And I understand defendant's counsel's arguments. The thing is, Mr. Reyes was not charged with violating the statute regarding no recording devices. He was charged with disorderly conduct, which is a very fact-driven case. I have lots of questions, but I can't ask you any of those questions, counsel, because your client has a right to remain silent. You all don't have to do anything but show up and watch. It's the state's burden when this case goes to trial, and it looks like it's definitely going to trial, to show that under the disorderly conduct statute here in Illinois, that your client committed disorderly conduct beyond a reasonable doubt. That's their burden. I have not heard any testimony from any of the witnesses, the police officers. I have no idea what they are going to say. Your client doesn't have to say anything. So because I have not heard anything, and I have no idea whether or not your client committed disorderly conduct under the statute, I cannot dismiss it. The state's attorney has a right to charge whatever the state's attorney wants to charge. I have had cases before where they were charged, the defendant was charged with the wrong thing. They have to show beyond a reasonable doubt under the statute that your client committed disorderly conduct. And that is a question of fact. So based on that, your motion to dismiss is going to be denied. And I think we should go ahead and set this for trial.